Welcome to Blue Card Prep Academy. Picture this. You're closing on a house. The seller takes the refrigerator with them. Is that allowed? What about the dining room chandelier, the built-in bookshelves? Every one of those questions has the same answer, and it starts with one thing: real property versus personal property. The exam tests this directly, and it comes up everywhere after this: deeds, contracts, disclosures, closings. Get it right, and a whole class of exam questions becomes easy. Get it wrong, and you'll keep second-guessing yourself. This is video 1 in the Real Estate Core Concepts for All States. We're starting here because everything else builds on it. So let's start with the core distinction: real property versus personal property. Here's what each one means. Real property is land, plus everything permanently attached to it, plus the rights that come with owning it. The house, the garage, the fence, the trees growing in the yard, all real property. Personal property, sometimes called chattel or personalty, is everything else. Movable items not permanently attached to the land. Your couch, your car, your laptop, the dishes in your kitchen. Why does this matter on the exam and in real practice? Because when a property sells, real property transfers automatically with the deed. Personal property does not. It has to be handled separately, usually with a different document. If you can't tell which category something falls into, you can't tell what the buyer is actually getting at closing, and that's where disputes happen. Here's the cleanest way to think about it. If it were sold tomorrow, would this item go with the land, or could the owner take it with them? That's the question the exam wants you to ask automatically. But here's the catch. Some items aren't so clear-cut. A chandelier was personal property when it sat in a box at the hardware store. The moment it gets bolted to the ceiling, it might become real property. That transition is what the rest of this video is about. A fixture is personal property that became real property by being permanently attached to a building or the land. The chandelier example, that's a fixture. Built-in bookshelves, a ceiling fan, a hot water heater, kitchen cabinets, all fixtures. Why does this matter? Because once something is a fixture, it's real property, and it stays with the house at closing unless the contract specifically excludes it. A seller who tries to take the chandelier on moving day is technically removing the buyer's property. So how do we actually decide whether something is a fixture? The standard test comes down to 3 factors. 1. Method of annexation. How is the item attached to the property? Bolted, wired, cemented, plumbed in. The more permanent the attachment, the more it looks like a fixture. Something held in place by gravity alone, like a freestanding refrigerator, usually stays personal property. 2. Adaptation to real estate. Is the item specifically adapted to this property? Custom-cut storm windows, a key that only fits this house's lock, a custom-fit pool cover. Those are built for this specific property, and that pushes them toward fixture status. 3. Agreement of the parties. What did the buyer and seller agree to in writing? The contract isn't a tiebreaker on top of the test. It's one of the 3 factors. If the sales contract says the chandelier does not convey, that agreement controls the outcome. That's why the practical advice in real transactions is always, if you care about a specific item, put it in the contract. A quick study tip. As you go through other prep materials, you'll see this taught with longer memory aids. Maria, with 5 letters for method, adaptation, relationship, intention, agreement, or Irma, with 4. Those versions add things like the party's relationship or what the installer was thinking. These are useful memory aids, but the actual framework you're expected to apply is the 3-factor version: method of annexation, adaptation to real estate, agreement of the parties. The practical takeaway: if the 3 factors together point toward this stays with the property, it's a fixture, it's real property, and it conveys with the deed. But here's where it gets more interesting. A trade fixture is a fixture installed by a commercial tenant, not the owner, for the purpose of conducting their business. A great example of this is a restaurant tenant leasing a building. They install a commercial pizza oven, bolted to the floor. They install custom booths along the walls. They mount a giant menu board behind the counter. By the standard fixture test, all of that looks like it should be real property. It's attached, it's adapted to the space, it looks permanent. But the law treats trade fixtures as an exception. Because the tenant installed these items to run their business, and forcing them to leave all that equipment behind every time they move would be devastating for any business tenant, trade fixtures remain the personal property of the tenant. The tenant can remove them at the end of the lease, as long as they repair any damage caused by removal and remove them before the lease ends. Miss that deadline, and a doctrine called accession kicks in. The trade fixtures convert into real property belonging to the landlord. Accession just means one thing got absorbed into another. It's now part of the real estate. So, a tenant who walks away from their commercial pizza oven on the last day of the lease isn't just losing the oven, accession has already turned it into the landlord's property. Definitely take note of this. They love putting this in the exam because it's a clean exception to a rule you just learned. Test writers will give you a scenario with a commercial tenant, an obviously attached item, and ask whether it's real or personal property. The answer hinges on the tenant relationship, not on how attached the item is. Okay, so moving on, the second big exception involves agriculture. Emblements, also called fructus industriales, are annual crops produced by human cultivation. Corn, wheat, soybeans, vegetables. Anything a farmer plants, tends, and harvests on a yearly cycle. Normally, anything growing out of the land, trees, perennial plants, natural vegetation, is real property and goes with the land when it's sold. But emblements are treated differently. Because the farmer invested labor and resources to plant and tend the crop, the law treats those crops as the personal property of the farmer, even though they're physically growing out of the ground. That's where the doctrine of emblements comes in. If a tenant farmer's lease ends before harvest, the doctrine of emblements lets that farmer come back and harvest the crop they planted. If a farm is sold mid-season, that crop may belong to the seller, rather than transferring with the land. There's one more thing the exam may test here. The right to come back and harvest only applies when the lease ends, for reasons outside the tenant's control. The property is sold, foreclosure happens, the landlord terminates, the landlord dies. If the tenant themselves voluntarily walks away from the lease or breaches it, that protection can be forfeited. The doctrine protects the farmer's investment of labor when something happens to them, not when they walk away from the deal. Contrast that with fruit on a fruit tree, or timber from a mature tree. Those are usually treated as real property, part of the land itself, because nobody planted them. They just grow. They're sometimes called fructus naturales, natural fruits. We've covered a lot so far. Real versus personal property, fixtures, trade fixtures, and emblements. Before we move on, let's make sure it's sticking. Quick quiz. Question 1. A seller is preparing for closing. Which of the following items would most likely be classified as personal property? The correct answer is B. The grand piano is movable and not affixed. That's the core test for personal property. A is wrong because detached describes a building separate from the main house, not an item that's unattached. A detached garage is still a permanent structure on the land, real property. C is wrong because a hot water heater plumbed into the home is a fixture, which makes it real property. D is wrong, because a fence permanently affixed to the land is real property. Material doesn't change the classification. Question 2. A homeowner installs a custom-built bookshelf into the wall of their living room, screwed into the studs and trimmed to match the existing molding. They sell the house. Is the bookshelf real or personal property? The correct answer is B. The bookshelf is a fixture, real property. The method of annexation is significant, screwed into the studs. The adaptation to this specific property is clear, trimmed to match the existing molding. The contract isn't mentioned, so there's no agreement of the parties carving it out. A is wrong, because who built it doesn't determine the category. C is wrong, because removability alone doesn't make something personal property. D is wrong, because trade fixtures require a commercial-tenant relationship. A homeowner doesn't install trade fixtures in their own home. Question 3. A tenant farmer plants soybeans on leased farmland in April. The landlord sells the property in October before the harvest, and the new owner takes possession. Who owns the soybean crop? The correct answer is B. Soybeans are emblements, annual crops produced by human cultivation. The doctrine of emblements treats them as the personal property of the cultivator. The lease ended because of the sale, which is outside the tenant's control. Exactly the situation the doctrine protects. The tenant farmer retains the right to harvest. A is wrong because it applies the general rule without recognizing the emblements exception. C is wrong for the same reason. D is wrong because there's no automatic split. The crop belongs to whoever cultivated it. Now we shift from what things are to how they move between categories. Attachment is the process by which personal property becomes real property by being permanently affixed to the land or a building. Remember that chandelier from the beginning? When it was in the box at the hardware store, it was personal property. When the homeowner wired it into the ceiling, it underwent attachment and became a fixture, real property. Attachment is just the formal name for the transition you've already been thinking about. A quick exam tip. When a question describes something being installed, affixed, built in, or permanently mounted, that's attachment language. The exam is signaling that the item may have crossed from personal to real property, and the fixture analysis is going to determine whether it actually did. Now flip it the other direction. If attachment moves something from personal to real property, severance does the opposite. It's how real property becomes personal property by being detached or removed from the land. A farmer harvests a crop, severance. A homeowner cuts down a tree and stacks the firewood, severance. The tree was real property while standing. Once cut, the wood is personal property. They put severance questions on the exam because they want to know if you can recognize a category change. An item that was real property a moment ago may have just become personal property, and that changes how it's transferred, taxed, and documented. So, if real property transfers with a deed, how does personal property transfer in a real estate transaction? The answer is a bill of sale, a written document used to transfer ownership of personal property from one party to another. Here's where this becomes practical. Imagine a home sale where the seller is also leaving behind the washer, dryer, refrigerator, and a riding lawnmower. None of those are fixtures. They're personal property. The deed will transfer the house, but it won't transfer those items. That's what the bill of sale is for. It's what actually transfers ownership of those items to the buyer. Two things to remember for the exam. 1. Deeds transfer real property. Bills of sale transfer personal property. Don't mix them up. 2. A bill of sale is the answer whenever the question involves transferring movable items in a real estate context: appliances, furniture, equipment. We've covered the full picture: real versus personal property, fixtures, trade fixtures, emblements, attachment, severance, and the bill of sale. Let's run through 7 questions that pull from across the whole video. Question 1. Which of the following is the best description of personal property? The correct answer is B. Personal property is movable, not permanently attached. A is too casual and not legally accurate. Many fixtures aren't literally nailed down. C is wrong because location doesn't determine category. A couch in a house is still personal property, and an outdoor fence is still real property. D is wrong because value has nothing to do with classification. Question 2. A commercial tenant operating a hair salon installs salon-specific plumbing, custom sinks, and floor-mounted styling chairs. The lease ends and the tenant removes all of it, repairing any damage. Was the tenant legally allowed to do that? The correct answer is C. Trade fixtures are personal property of the commercial tenant and can be removed at lease end, provided any damage is repaired and removal happens before the lease ends. A applies the general fixture rule and ignores the trade fixture exception. B is wrong for the same reason. Bolted down doesn't override the trade fixture rule when the installer is a commercial tenant. D is wrong because trade fixture removal rights exist as a matter of law. Specific lease authorization isn't required. Question 3. A farmer has been leasing farmland and planting wheat each spring. Halfway through the growing season, the landlord dies. The land passes to the landlord's heirs, who want the farmer off the property. Under the doctrine of emblements, what happens to the wheat crop? The correct answer is C. The landlord's death is outside the tenant's control. The doctrine of emblements protects the farmer's investment of labor when the lease ends through no fault of their own. A applies the general rule and ignores the emblements exception. B is wrong because there's no automatic split. Emblements belong to the cultivator. D is wrong because crops aren't destroyed when ownership changes. Question 4. A homeowner buys a new ceiling fan and hires an electrician to wire it into the ceiling of the master bedroom. From a property law standpoint, what has happened to the ceiling fan? The correct answer is C. Attachment is the process by which personal property becomes real property through permanent affixing. Wired into the ceiling with intent to remain, textbook attachment. A is wrong because removability alone doesn't keep something personal property. B is backwards. Severance moves things from real to personal property, not the other way around. D is wrong because trade fixtures only apply to commercial tenants. Question 5. A property owner cuts down a 50-year-old oak tree on their land and sells the lumber. At the point the lumber is sold, what kind of property is it? The correct answer is B. The tree was real property while standing, but severance, cutting it down, converted the lumber to personal property. A applies the rule for standing trees, not severed lumber. C is wrong because severance ends the permanent status. D is wrong because emblements are annual cultivated crops. A 50-year-old oak is natural vegetation, fructus naturalis, not an emblement. Question 6. A buyer and seller close on a home. The contract specifies that the existing washer and dryer convey with the property. What document should be used to transfer ownership of the washer and dryer? The correct answer is C. Washers and dryers are personal property, movable, not permanently attached. The deed transfers real property only. Personal property requires a separate bill of sale. A is wrong because the deed doesn't transfer personal property regardless of what the contract says. B is wrong for the same reason. D is wrong because a sales contract is the agreement to transfer. The bill of sale is the actual transfer instrument for personal property. Question 7. A homeowner installs a built-in dishwasher, screws it into the cabinets, and connects it to the plumbing. 2 years later, they sell the home. The contract is silent on the dishwasher. Does the dishwasher convey to the buyer? The correct answer is C. The dishwasher underwent attachment, screwed into cabinets, connected to plumbing. The method of annexation is significant. The adaptation to this specific property is clear, and the agreement of the parties is silent. Nothing in the contract excludes it. It's a fixture and conveys with the deed. A is wrong because always is the giveaway. Appliances can become fixtures through attachment. B is wrong because contract silence triggers the default rule. Fixtures convey unless specifically excluded. D is wrong because fixtures convey automatically. And that's real versus personal property. This one shows up everywhere: deeds, contracts, disclosures, closings. Every time you see a question about what transfers with a property, this is the foundation. Make sure it's solid before you move on. If you found this useful, subscribe so you don't miss the rest of the real estate exam core concepts for all states. That's where all the national portion topics live, reusable no matter which state you're testing in. Check it out for related topics.